Hey, it's Bill Gross, the LA Probate expert, bringing to you another professional in the business. And this is not just a professional, this is really, I think, the subject matter expert of tenant law, evictions, and that whole process out of Northern California, attorney Daniel Bornstein. Daniel, welcome. So nice to get a chance to talk to you today.
Thank you. Thank you for the opportunity to speak to your audience. It's my pleasure.
Just real quick, a little background. Where'd you grow up and how'd you get into the practice of law?
I grew up in Cleveland, Ohio, and migrated out to California to attend Berkeley in 1988. Loved it so much that I remained a Californian and gravitated to law because I have a facility with language and felt that I could help people by using some of the gifts that I have to help resolve disputes, which is something I'm proud of.
Now, you have a fairly focused practice on tenant, evictions, landlord law, that whole subject matter. How'd you end up in that particular niche?
Very good question. So when someone tells you they practice real estate law, that doesn't tell you anything. You have
Right.
to ask them what you do every day. And what I do every day is landlord-tenant disputes on behalf of property owners, real estate investors, mom and pop owners, brokers. And I got into it because I wanted to have my own practice. And having graduated law school, I learned rather quickly that there were so many landlord-tenant disputes existing throughout the state that if you wanted to start out, you could start out opening up your own small practice by assisting people in resolving these disputes. And ever since I came out of law school, this is what I've done. And after 28 years of it, I've gotten a comfort level where I can see past the horizon of the dispute and seemingly know where things are going to likely end up. Sometimes I get surprised, and during the COVID pandemic, it's even more cumbersome. But generally, after having resolved thousands of disputes, I feel really comfortable in this space. And with an attorney and hiring an attorney, you want to hire an attorney who's able to see past the horizon of the dispute to be able to know how and under what conditions it's going to resolve. And that requires that attorney to be doing that work all the time on a daily basis.
Now, I know that we have significantly different rules in different cities and counties. I also know we have a whole set of new rules because of COVID, and you in fact did a long piece on those details, of, particularly Northern California, current COVID restrictions. And so I'm going to link that in the chat box. We have to go through that today. One thing that surprised me was I saw a video you had done of where you did a speech that was disrupted by some activists. But that was, I didn't notice till the end, that was like 8 years ago. So this tension between landlord and tenants has been, I want to say militant. Is that too hard a word? For the last
I think that's a very fair assessment. Housing throughout California is fraught with tension. It is political. We have a large cohort of community members who are unhoused. And what I do is terminate tenancies at times. And the perception that terminating a tenancy may lead to homelessness is something that, of course, is political. And I'm proud of the work I do on behalf of real estate owners and new homeowners buying their first property.
Yeah.
But it does come with the difficulty of the politics of our country, the politics of California, and the particular politics of Los Angeles, which we know has a emerging homeless population, and the Bay Area, which has got the crisis as well. We need to build more housing, and then the politics will dissipate and the tension will dissipate. But until then, we've got a crisis, and I'm seen as, in some respects, on one side of the crisis, and you have to have thick skin. And it is a blood sport because you are at times giving people bad news that they have to make a chapter change in their housing life. And that's something that you have to be courageous enough to handle on behalf of clients.
I'm a real estate broker, primarily focused on probate real estate. And it sounds so easy to say, well, I'm supporting a rich landlord who's kicking out a tenant. I had a case most recently where the squatter was basically there with no rent, no expenses. But my owner was literally in an old age home, living a semi-destitute life. She had a property that her husband, who was a war hero, left her worth $800,000, which would have provided income for her to live a nice, dignified life. Her husband had worked for and died, as a result of some medical complications. So here's a war hero's widow who's living in destitute because a squatter, won't take responsibility. Sometimes these things are more complex than they see at first blush.
Oh, absolutely. And there's an appearance versus reality. The perception of a housing provider versus the reality is very different.
Mm.
And, you know, I would only work on behalf of a matter that I believe in and that I believe is justified. And I fundamentally believe that if someone is occupying a premises and you are an owner and you want to end the relationship, you should be able to do so, provided you're complying with the law. And the law is admittedly very tricky. And then you have the overlay of COVID protections. You also have state just cause and state rent control. And then you have local ordinances such as the Santa Monica ordinance or in San Francisco or Berkeley. When I started 28 years ago, there were 3 rent ordinances in the Bay Area. There was Berkeley, Oakland, and San Francisco, and now there's 15. And so you really have to get acculturated and educated to the very balkanized nature of rent control and just cause eviction rules. And as a result of it, I'm a person that is oftentimes in need. I've been very busy.
It seems like, and again, we want to get into the details though, because you did a great presentation. I want to link to it. I think anybody who's a professional should watch that, not just because of, like, I'm in Southern California, don't come across much of Northern California as far as real estate eviction, but just the principles are the same, that these things are changing, that they're detailed, you have to follow the rules. I thought you did a really great job. Do you see the process, you know, I know COVID restrictions are easing, we have to wear masks, we can go in groups. There's still some restrictions, primarily government-based restrictions. Do you see, I know there's restrictions that have eased a bit statewide and countywide here in Los Angeles, but not citywide. But on one hand, while those restrictions legally are easing, enforcement seems to be ramping up and still difficult. Do you see the process easing a bit, or do you see, like I do, it's still tense and getting tenser all the time as far as the ability of landlords to get tenants out to follow the law?
Over the course of my career, it's become more and more challenging, more and more difficult, more and more bureaucratic. During COVID, obviously, because of public policy considerations, the courts were closed. The courts are opening up. And so we're moving towards where we were pre-COVID, but it's not over. And on top of it, the optics of displacement of occupants during a time of crisis is something that people have to consider. Most importantly, though, whereas maybe 15 years ago, you can pull a doc off the internet from Nolo Press or something and think you've got a good termination notice.
Right.
I have to caution you, it's so complicated and cumbersome. You really don't want to pull stuff off the internet and think you've got a proper notice, because there are so many drafting requirements that it's what you don't know that gets you in trouble. Right. And I often give an anecdote is, look, if your cousin is in Redding, California, and he practices, you know, insurance defense law, the fact that you have a free go-to attorney doesn't mean that he's any bit less dangerous than you are in handling a landlord-tenant dispute. It's a very niche area of law. And if you are involved in a landlord-tenant dispute, you do want to get an attorney who's doing that all the time. And it's very fair to ask a prospective attorney that you may work with, do you handle landlord-tenant matters on a daily basis? Do you handle probate beneficiary in possession of a unit post COVID? Do you handle owner move-in terminations? Do you handle state rent control, just cause eviction rules? And if they say no, then you want to really go to that person or get a recommendation on someone who's handling it all the time.
100%. You know, as a real estate agent who is referring people to attorneys daily, it's so important to find somebody who specializes in that particular activity to get the result you want. I don't care that you do 50 things. I want one thing done, and I want an expert in that field. I find sitting in court daily pre-COVID, I saw there's a big difference between people who know what they're doing and people who, you know, aren't experts in that area, just to leave it. Yeah. One of the things you mentioned, I really make sure I get a chance to talk about today, is in probate, we have often cases where there's multiple family members, one of them is an heir, maybe one not living the property is the administrator or the executor of the estate, but there's always one living the property who claims to have the closest relationship with the parent, took care of the parent perhaps, you know, maybe it's even true, but legally has no more rights as a beneficiary than the other kids, but holds up to sell the property because he doesn't want to take his money and go somewhere else. So there's a legal terminology for that. And what's that process is easier to get out than a regular tenant or holdover tenant, or is it the same process? How can you describe that for us?
Sure. So what you're really identifying is that you have maybe a family member who does not have a landlord-tenant relationship with the ownership, but has permission to occupy the premises. That person would be deemed a licensee, not a tenant. And with my assistance, I can always help determine whether the individual inside a unit has a tenancy, which may be protected under a local jurisdictional ordinance, or whether someone is merely a licensee, someone who has permission to occupy the premises. Beneficiaries without a lease agreement, without a security deposit, who were put into the unit simply because they're family members and there's love. If there's a transition and the new trustee wants that person to vacate because they want to sell the property vacant, clean up the property and maximize the sale, and that beneficiary does not want to leave, well, that's an opportunity to have a dialogue with my office. And through a process of questioning, I can come to a determination as to whether the person is merely a licensee. If the person is deemed to be a licensee and not a tenant, then you have the right to just send them notification that they have to vacate the premises within a fixed period of time. And if they don't vacate the premises, then you have perfected your right to file what we call a forcible detainer, where the individual is forcibly detaining possession of the unit. The process is very similar to an unlawful detainer or a landlord-tenant eviction. It is an eviction. It just is predicated upon a different theory. And because the individual doesn't have the protections of, let's say, Santa Monica's just cause eviction rules, you don't have to jump through many hurdles. You simply have to prove that they don't have a tenancy. You've asked them to leave, they refuse to leave. And within 60 to 90 days after filing the lawsuit, you should be able to recover possession of the premises, with one big caveat, that you're working with an attorney who is capable of handling these type of disputes. One last point about this is that I do a lot of work on negotiating voluntary move-outs and avoiding court. So in the process of negotiating maybe a resolution to a beneficiary who doesn't want to move out, I may try to negotiate a deal before we start the legal process. It's always preferred. And often I want people to recognize that because 98% of all eviction lawsuits get settled, they don't go to trial. A lawsuit is really a leveraged buyout discussion. You get into the lawsuit so that you can have a better position to negotiate a deal for that person to vacate and be able to enforce it through a sheriff's eviction because you filed the lawsuit. I'd be happy to provide even more guidance on this in a longer, more concrete dialogue with you, but it's my pleasure to speak with your group and also to let people know that it's a privilege to educate people. This is complex, confusing stuff, and you do need to have someone who is comfortable with this to give you good guidance.
Well, as we're recording this, this is really more of an interview. For those who are watching, we plan to schedule Daniel for a longer version live stream, and there'll be participation. We can come in and ask questions live as well. So that's going to be, stay tuned for that going forward. So last question I have on kind of tactics, because I know we're limited time-wise. Well, actually, let's do this because I think we are up against the time. If somebody, an agent, a real estate agent I work with, or investor, wholesaler, had a property, or a family has a property that somebody's in it, whether it be a squatter or a tenant who's overstayed, or a beneficiary they're having difficulties with, what's the best way for them to get in contact with you to have that discussion?
Yeah, easiest way is to email me, daniel@bornstein.law. And then I send a client intake form. I ask for a couple documents scanned to me, and then we can set up a meeting. Half-hour meeting is usually all I need in order to give you a guideline on what I think you can do, what I think you ought to do, and then give you a strategic map on how to accomplish the goal. Or if the goal can't be accomplished, I'll be forthright and say it's a mess and I don't have an easy solution for you. I pride myself on being as forthright and blunt as possible, so there's no confusion between the communications I have with clients.
And I just had to tell for everybody who's listening, I spoke to him previously about the subject of the beneficiaries from the property, and I've been involved in a number of evictions. None of the local attorneys I talked to have ever even discussed the matter with such clarity and the distinction of the position you're in if it's a probate and you have an executor versus just a plain tenant. So I appreciate the time we spent today. I look forward to meeting with you at length again. Daniel, thank you so much.
No problem. It's my pleasure, and thanks for the invitation. Happy to come back.
Thanks.